This presentation provides a broad outline of the April 2013 civil procedure reforms in England and Wales. Other presentations look in a little more detail at individual areas. Sir Rupert Jackson's review of civil litigation costs, final report, was published in December 2009, a little more than 10 years after the civil procedure rules first came into force. In Sir Rupert Jackson's view, in some areas of civil litigation, costs are disproportionate and impede access to justice. His aim was to produce a coherent package of interlocking costs and other reforms designed to control costs and promote access to justice. The major part of these reforms came into effect on the 1st of April 2013. Some of the reforms address costs directly, others more indirectly. At the heart of the reforms is a new costs management regime by which the overriding objective is amended to state that, in addition to dealing with cases justly, the overriding objective is to deal with cases at proportionate cost. New procedures, costs management hearings and mandatory costs budgeting are supplemented by new powers to make costs capping orders. The possibility of obtaining a costs capping order extends to appeals. Sir Rupert Jackson's proposal for one-way qualified costs shifting has been implemented. Under this new regime, in personal injury cases, there's no longer symmetry between the position of the claimant and the defendant when it comes to costs orders. If the claimant wins, they can expect a costs order in their favour, but if they lose, they can expect not to have to pay the defendant's costs, subject to exceptions to prevent abuse. When it comes to detailed assessment of costs, in all cases where the bill is drawn at less than £75,000, the provisional assessment will be carried out on paper, and the costs of drawing the bill will be limited to £1,500. In the view of Sir Rupert Jackson, conditional fee agreements, or CFAs, of which no-win, no-fee agreements are, in his terms, the most common species, have been a major contributor to disproportionate costs in civil litigation in England and Wales. He identified two key drivers of cost under these arrangements. First, the lawyer's success fee, and second, the after-the-event insurance premium that's usually taken out when a CFA is entered into to cover the claimant against the risk of having to pay the defendant's costs. Both the success fee and the ATE insurance premium were previously recoverable from an unsuccessful defendant, but under the reforms, success fees and ATE insurance premiums cease to be recoverable from unsuccessful opponents. Of itself, this would mean that the success fee came out of the damages awarded to the claimant, which, bearing in mind that tort damages, at any rate, are designed to provide no more than the figure necessary to compensate the claimant for the injury, then the proposal would leave the claimant undercompensated. Accordingly, Sir Rupert Jackson recommended that there should be an across-the-board increase of 10% in general damages for purpose of compensating for this shortfall in a rough and ready way. Since this called for a change in the common law of damages, it had to be left to the courts, and in Simmons and Castle, the Court of Appeal obliged and pronounced such an increase. In consequence of these changes, it can be expected that conditional fee agreements will seem less attractive to claimants. Accordingly, a new method of litigation funding has been borrowed from the United States, to be known here as damages-based agreements, or DBAs. Under these, subject to limits, it becomes lawful for the first time for lawyers in English litigation, at any rate outside certain employment cases, to charge on the basis that the lawyers receive a proportion of the damages recovered. These arrangements were previously shampitous in English law and therefore void. One of the most powerful tactical tools available under the civil procedure rules is the offer to settle under Part 36. In order further to incentivise defendants to accept reasonable offers of settlement from claimants, the new rules allow for an additional prize to a claimant for making a successful Part 36 offer. Now, by successful Part 36 offer, what I mean is an offer which is made by the claimant, not accepted by the defendant, the case goes to trial, and the claimant achieves at trial an outcome better than the offer that they had previously made to the defendant, as seen from their viewpoint. Well, where that happens, there is going to be an additional prize available to the claimant. That is to say, where the claim is a money claim, the claimant can expect to receive an additional 10% on top of the award. In other cases, there will be further enhanced costs. Now, changes in case management include an increase in the small claims track limit from £5,000 to £10,000. When it comes to case management conferences, Sir Rupert Jackson's belief that many CMCs were unnecessary because they were merely formulaic, with standard homemade directions being given by case management judges. And that view has resulted in proposals leading to new rules by which directions questionnaires will replace some allocation questionnaires, and where parties have agreed directions in multi-track cases, those directions have to be submitted ahead of the case management conference. Tailored disclosure orders are expected to be made in the place of standard disclosure in multi-track cases, and there'll be a new discretion to limit factual evidence placed before the court. And when it comes to expert evidence, estimates of costs will be expected, and new procedures for clarifying expert issues are to be introduced. A procedure which is well established in international arbitration and which has been trialled in court cases in Manchester is expert conferencing, and that's to be introduced. It's also known as hot tubbing, by which expert witnesses in the same discipline will give their evidence concurrently. Well, that concludes this review in very, very broad outline of some of the major April 2013 changes. Other presentations will look in a little bit more detail at specific issues. Thank you.